Hello, my name is Vivek Pandey, and in today's this session I will be discussing the issue of pendency of cases in the courts of India. When it comes to justice delivery system of any country, then pendency of cases in the courts across that country is an important measure. If we talk about India, then in recent decade, in this aspect, we have seen a significant deterioration. From the data on the screen, you can see that as of July 1, 2021, there are 44.9 million cases pending in the courts of India. Out of these 44.9 million cases, 39 million cases are pending in the district and subordinate courts, 5.85 million cases are pending in the high courts, and more than 69,000 cases are pending in the Supreme Court of India. Also, if you will further pay attention to the data on the screen, then you will notice that as of January 1, 2006, there were 29.2 million cases pending in the courts of India. But now, after 15 years and 6 months, this number has increased by almost 15.7 million to 44.9 million cases. It is an astounding increase of almost 1 million cases per year. So, what are the implications of such a huge pendency of cases? What are the reasons behind it? And most importantly, how this problem of pendency of cases could be addressed. In our this session, we will talk about all these aspects in a very detailed and proper manner. So let's first discuss about the implications of the huge pendency of cases. So first implication of such a huge pendency of cases is the increase in corruption and crime. The increase in corruption and crime is a direct fallout of the sluggish justice delivery system. The rich, the powerful, the wrongdoers have a field day in getting their cases delayed. It severely impacts the marginalized and the poor. According to one estimate, more than 70% of prisoners are under trials, and they are mostly poor citizens. For marginalized and poor, the judicial process itself becomes a punishment. The second implication of the huge pendency of cases is the delay in disposal of cases. If you will look the table on the screen, then you will get to know that more than 3.7 million cases are pending for more than 10 years. 6,40,000 cases are pending for more than 20 years. and 1,94,000 cases are pending even for more than 30 years. If you will add all these, then you will notice that more than 4.5 million cases are pending for more than 10 years in India. The third implication of the huge pendency of cases is the injustice. Let's take some example. You all must be aware about the case of Vishnu Tiwari. In March this year, he was held not guilty of rape by the Allahabad court after he had spent 20 years in jail. What did he have after 20 years? Rupees 600. That's it. No one is accountable for his tragedy. In 1996 Samleti blast case, 6 men were held not guilty by the Rajasthan High Court after they spent 23 years in jail without bail or parole. Again, no one is accountable. Deepak Jaisi, a Nepali citizen, was ordered to be released by the Calcutta High Court this March from the Damdam Central Correctional Home after spending 40 years in judicial custody as an under trial prisoner. He was alleged to have been involved in a murder in Darjeeling district in 1981. Another truly amazing case is that of Premchand. In 1982, a sample of turmeric was taken from his shop and found to be adulterated with some living mealworms. He was tried but acquitted of the charge of food adulteration in 1995 after 13 years. Then the prosecuting agency appealed to the High Court and he was convicted after 14 years. Thereafter, he appealed to the Supreme Court and finally it took 11 more years for the Supreme Court to acquit him in 2020. So he spent 38 years in the courts of India. First 14 years in the district and subordinate courts, then 13 years in the high courts and then 11 years in the Supreme Court in pursuance of justice. All these are examples of common folk. But what about the murder of an VIP? Alan Misra, the railway minister, was killed in a blast in 1975. The accused were pronounced guilty by the trial court after almost 40 years in December 2014. Imagine the physical and mental trauma that innocent person suffers for years in jail and the hardships faced by their family. Who cares? More often than not, even monetary compensation is not paid to them. The fourth implication of the huge pendency of cases is the unhappy society. The connection between law, governance, and happiness has been gaining considerable attention over the years. United Nations World Happiness Report has shown time and again that countries with a higher GDP and higher per capita income are not necessarily the happiest. The United Nations World Happiness Report of 2021 ranks India 139 out of 149 countries. Law ought to bring happiness to the lives of people. The great degree of unhappiness in Indian society has lot to do with the way the law and its institutions operate. People live in pain and anguish as their legitimate grievances remain unaddressed by the legal system. The estimated figure of 4.49 crore pending cases in various courts of country is not merely a number, as those connected with all these cases are in a state of anxiety, and they are certainly not the happy people. India's rule of law rank was 69 as per the World Justice Report 2021. It has a chilling effect on the right to life, liberty, economic justice, dignity, and national integration. People are rarely satisfied with the police and the courts. In this country, crime and its resultant suffering are a major source of unhappiness. So, now when we have discussed the implications, let's see the main reasons behind such a huge pendency of cases in India. The first and foremost reason is the existence of vacancies across the judicial system. The 24 high courts in the country have a combined sanctioned strength of 1080 judges, but as of May 1, 2021, they were functioning with only 420 judges. Similarly, the lower judiciary also has 5,000 vacant positions. There were also 5 posts of judges in the apex court that were lying vacant. However, recently in September 2021, 9 judges has been appointed in one go, taking the strength of Supreme Court to 33. The second main reason behind such a huge pendency of cases is an Indian phenomenon called luxurious litigation. Basically, it is a specific type of litigation where people with the resources attempt to frustrate the judicial process and delay it by filing numerous proceedings, mostly bogus cases across the judicial system. The third reason that jurists cite is the inadequate infrastructure in subordinate courts. In 2018, then Chief Justice of India Deepak Misra himself accepted that most subordinate courts lack basic infrastructure for judges, court staffs and litigants. The fourth main reason behind the pendency of cases is the culture of seeking adjournment. In 2018, President Ramnath Kovind said that there is a culture of seeking adjournment as a norm rather than exception. However, he had also noted that new thinking is gradually taking place on frequent adjournment. The judiciary is making sincere effort to curb the practice. The fifth reason is the pandemic, COVID-19. The prevailing pandemic has also contributed to our ooze. The courts have not worked with a full caseload since March 2020. As a result, the pendency has risen precipitously across the judicial system. When the lockdown of March 2020 was declared, there were 3.68 crore cases across all levels, which have already shot up to 4.49 crore. We have already seen this at the beginning. So, what are the strategies that are suggested to clear this backlog of pending cases? The first and most important strategy that could be followed is the filling of sanctioned judicial positions. Analysis show that between 2006 and 2019, the average increase in pendency of cases was less than 2%, whereas the average vacancy in sanctioned position was about 21%. If the sanctioned judicial positions had been filled, pending of cases would not have gone down further. Once former Chief Justice of India T.S. Thakur claimed that to clear all this backlog of pending cases, more than 70,000 judges are required, but estimate so that India neither needs 70,000 judges nor does it need to double the present number of judges. It needs to add around 20% of judges. This is in line with the sanctioned strength in the judiciary. The responsibility of selecting judges largely lies with the judiciary itself. When it comes to appointment in subordinate courts, then the responsibility lies with the state government and the respective high courts. The responsibility of ensuring zero vacancy should be with the Chief Justices of the High Courts and the Chief Justice of India. They should be held accountable for the same. Right now, nobody believes that they are acting in an accountable manner, and filling judicial vacancies is not considered a matter of priority. Filling all vacancies, all these sanctioned vacancies may result in a requirement of about 5,000 courtrooms. A simple solution would be to run 5,000 courts in 2 shifts. The second strategy that is suggested is to improve working with the use of technology. The E-Committee of the Supreme Court came into existence in 2005, and it has recommended 3 outstanding suggestions. The first its suggestion is the computer algorithm that could decide on case listing, case allocation and adjournment with only a 5% override given to judges. All rational reasons and limits should be put on adjournment. The case listing should be done on the basis of first in, first out, and the case allocation should also take into account logical criteria. This would be a big step in reducing arbitrariness and unfairness and the unfair advantage that the powerful enjoy in this country. The second suggestion that E-Committee of the Supreme Court has made is the e-filing of petitions, affidavits and payment of fees. The E-Committee has made detailed standard operating procedure on how petitions and affidavits can be filed, and payment of fees can be done electronically without lawyers or litigants having to travel to courts or use paper. This should be implemented in all seriousness and would also save about 3 lakh trees annually. The third suggestion that E-Committee of Supreme Court has given is that all the courts of the country must switch to hybrid virtual hearings. And they should start disposing cases. In pre-COVID-19 years, the increase in pendency of cases in all courts used to be around 5.7 lakh cases per year. In 2020 alone, it increased to an astonishing 51 lakh. It appears that if a hybrid virtual hearing model is not adopted, the backlog of cases could cross 5 crore in 2022. The dysfunctional justice system will be perpetually overwhelmed then. COVID-19 has prompted the courts to adopt virtual hearings. Even when once COVID crisis ends, it would be beneficial to continue hybrid virtual courts. This will make access to justice easier for litigants, reduce costs, and also give a fair opportunity to young lawyers from the small towns. The required hardware for conducting virtual hearings is also already available with the courts. All these recommendations, be it filling sanctioned judicial positions or making Chief Justice of High Courts and Chief Justice of India accountable for the same, or to improve working with the use of technology, the computer algorithm, the e-filing of petitions, affidavits and payment of fees, or conducting hybrid virtual hearings. None of these would require changes in law. And all these suggestions are based on the Supreme Court's various decisions and its committee recommendations. If all this done, India's judicial system will be among top 10 countries of the world. It will not only make India a preferred nation for investment, but will also fulfill the fundamental right to speedy justice of the citizens. Before I end our today's this discussion, I would also like to briefly talk about the interesting case of California. On the screen, from the table, you can see that the cases in California has been compared with the 3 states of India. The first state is the Bihar, which has almost the same percentage of population as California. The second state is the Telangana, which has almost the same population as the California. And the third state is the Uttar Pradesh, which is largest state in India. In 2019, all these 3 states combinedly disposed about 3.5 million cases, and they had around 6,000 judges. On the other hand, in the state of California in 2019, around 4.1 million cases were disposed, and it had only 1,754 judges. It's true that the nature of cases in California and in all these 3 states of India may be different, but what is important in the present context is the number of cases and the output of the judges. The figure speak for themselves. The output of about 6,000 judges in these 3 states is less than the output of about 1,754 judges in California. While the nature of cases is not known, surely we have something to learn about and think about. An initiative must be taken and effort should be made to study the judicial system of California in order to further improve our justice delivery system. On this note, I will end our discussion here. See you all in the next video with another fresh topic. Thank you.